Williams.
I'm grateful, my Lord. Just before I get into the legislation, as I promised or threatened, depending on how you take it, just a couple of small points to pick up on from this morning. Firstly, I said that I would give the reference to the practice direction controlling the cost of the medical evidence, so don't invite the court to turn it up unless it wants to. But it's page 878, and it's practice direction 27B. You'll find there's a sort of term of art called a fixed cost medical report, which in the first instance is limited to £180. So that's page 878. I also said there were limitations as to whether there was evidence, oral evidence at all, and if so, who could give it. And that's the same practice direction at this time at page 886. It's really paragraphs 3.16 and 3.17. The only other point I was
that basically says oral evidence from the medical experts is normally not.
What it says is the only you can only have oral evidence of fact, so there's no facility for oral evidence of opinion.
Right.
Yes. And then that's, of course, I should also say, consistent with practice across the small claims track, where in general, if you need live expert evidence, it's not suitable for the small claims track. The only other document I was just going to briefly show, just to put into context some of the debate that was being had about the practical consequences and would it lead to additional complication. I just thought I expect some members of the court might have looked at this already, but in case some members haven't, I was just going to show you the relevant part of Mr. Rabot's medical report, which is at page 231. And this is just a report prepared by a GP, as you might expect, given the control on the cost. And it just lists the effect on hobbies, lifestyle and sport, and it's sleep pattern disturbed, morning stiffness on waking, carrying heavy items, bending, exercise, driving for long periods, socialising, moving bins. I think that's the passage that members of the court, my Lord the President, referred to. Now, obviously, it makes no effort to isolate those to a particular loss of amenity, still less to explore what I've suggested would be the entirely counterfactual exercise of asking, well, what would the situation have been had only one of the injuries been suffered, the non-statutory injury. So it's against that background that we do say that
the current symptoms indicate if the neck and lower back, which are the whiplash injuries, were 7 to 8 out of 10 pain severity, but the knees are only 2 to 3 out of 10.
Yes, they had resolved.
Yes, but the painfulness of the neck and lower back is not taken into account in calculating the tariff amount, is it?
No, it isn't, no. And that might, my lady, be a sort of artefact of the traditional approach, which obviously this was a new scheme and experts might be having to play a certain amount of catch-up, because historically that sort of attribution as to...
No, I wasn't making a point criticising the doctor for including that. I was simply pointing out that actually that was where most of the pain and suffering perhaps was.
By the time of the medical report.
By the time of the medical.
But I mean, certainly, as the Master of the Rolls accepted, we would say that by definition, pain and suffering from a knee injury must be different pain and suffering from a neck injury. It's a different part of the body. So what one is really talking about isn't, and I think, again, this may be a point that my Lord the President put to my learned friend, it's not so much an overlap of P and S, it's an overlap of LA. And so far as the LA is concerned, the passage I've just shown you at page 231, of course, is in the perfect tense. The patient found it difficult. So it's looking backwards. It's not what he's finding it difficult to do. It's in the past tense.
That's on the next page, on 232.
232 is the section that my lady put to me. Page 231 is the identification of the loss of amenity. It's all pretty trivial, if I can say so. Depending on where you live in the country, if Mr. Rabot lives where I live, you take out your bins once a fortnight. But it doesn't explain whether that's the knee, the neck, or both.
But not being able to drive, the significance of that in restricting your movements is also dependent, also is affected by where you live. If you
Where
live
you
in
live
a
and what you
rural
do.
area, then it's maybe more difficult
Yes.
to live your life if you can't drive.
Yes, I mean, in fact, my lady, just an illustration of that, I'm not suggesting it helps the court particularly, but an illustration of this, Mr. Briggs was a taxi driver. So if he had suffered this loss of amenity, then a discomfort after driving for long periods might have been quite a considerable loss of amenity. But for a different person who perhaps doesn't often drive for long periods, it would be, for want of a better term, trivial.
And on page 233, would you say that both the neck injury and the lower back injury are whiplash injuries within the meaning of the term?
Well, given the statutory definition and subject, I suppose, to potential arguments about the potency of the definition, which I know your ladyship is very familiar with from a case last year, I would agree that although whiplash is used as a convenient statutory label, it does appear to be encompassing something which is broader than the traditional use of that term. And the example my Lord the President gave about a parcel striking somebody when if it was propelled forward by rapid braking and led to a bruised neck. I can see that on the face of it, and subject to arguments around the potency of the definition, that would on the face of it be a whiplash injury within the meaning of the statute. Is that perhaps a convenient time for me to come to the statute? Grateful. So just to introduce it, the Act itself, as the court would have seen, is described by Lady Justice Nicola Davies in the lower court as a statutory incursion into the common law assessment of damages and a radical departure from fair and reasonable compensation. That's her term. Or the Master of the Rolls described it as 100% compensation. And as I understand it, none of us at the bar take issues with any of those characterizations. So it is the statutory incursion. As a modification of the common law, the principles collected by Lord Sumption in the Lachaud case apply. And I know they'll be familiar to the court, but I was going to briefly invite their turning up. It's at page 403. So it's paragraph 13 of Lord Sumption's judgment, taking it up at the second sentence. Parliament is taken to have known what the law was prior to the enactment. It must be therefore taken to have known about various defamation decisions, because of course this is a case about the Defamation Act. There's a presumption that the statute does not alter the common law unless it so provides either expressly or by necessary implication. And I think Mr. Weir and I both have put some emphasis on necessary implication and the satellite authorities that there are about what that means in a statutory context. But obviously the Lord Sumption goes on to say, but that doesn't mean you give the enactment a strained interpretation. It means only that the common law should not be taken to have been altered casually or as a side effect of provisions directed to something else. And we respectfully submit that that is a passage that has some resonance in the present case, certainly from the view expressed by the Master of the Rolls, that although he grants the statute is not a statute which is addressed at whiplash injuries, it has nonetheless, as an inexorable consequence, as he sees it, of its prescriptions in respect of whiplash injuries, changed the common law in respect of other injuries as well. And then the other principle, the last of the third principles, is cited just above marginal E. Even where some change to the common law was intended, it should not go any further than that. Parliament cannot be presumed to have altered the common law further than was necessary. So that's, in that now well-known, if I can respectfully say so, synthesis by Lord Sumption of the principles established in the earlier case law. I was also going to show you, if I might, a pithy summary of the position by Lord Justice Lewison, which in fact my learned friend cites, my learned friend Miss Hitching, which is the Zuberi case, which the relevant passage is at page 450. Where at the foot of the page, paragraph 31, Lord Justice Lewison says, although Parliament may abolish, modify or displace any common law rule, there's a general presumption that it did not intend to make changes to the common law expressly or by necessary implication. There's that phrase again. He cites Bennion. In considering whether a statute has displaced the common law, the court must consider the extent to which the legislative purpose would be undermined by the continuing existence of the common law operating alongside it. See Bennion, where a legislative scheme is comprehensive. That may be an indication the common law has been displaced, and he cites Bennion again. Now, in the present instance, we make the antithetical point to that. This is clearly not a scheme which is comprehensive. It addresses damages only in respect of whiplash injuries. And therefore here we can necessarily see the common law has been left intact, working alongside the quantification of damages for whiplash injuries to the extent that there are different forms of injury. So that's the point made by Lord Justice Lewison as an a fortiori point in the present context is the opposite of that. This is not a comprehensive scheme. And so there is, perhaps for that reason, an additional reason to suppose that the common law has not been displaced, because it manifestly has not been. And well, one might also say this, where one clearly does not have a wholesale substitution of a statutory regime for a common law regime, and the common law is left partly intact, then to the extent there is a parliamentary purpose of eroding the common law, you might expect to see that expressly spelled out, or certainly signposted in an unambiguous way. And when I come to the statute in the moment, we're going to submit that certainly, as my learned friend would have the interpretation, Miss Hitching would have the interpretation of the statute in respect of non-whiplash injuries, it is certainly not in any sense spelled out in an unambiguous way that there has been any change in respect of the assessment of damages for that sort of injury. So I was just showing you Zuberi and Lex law. Then so far as the point about necessary implication is concerned, again, I do recognise that this will be very familiar to the court, but again, there's been another recent synthesis by I think it's the divisional court, in fact, Lord Justice Popplewell giving the judgment in a case called Nippon, Euston and McLaren, which I was going to turn up at page 538. Sorry, I beg your pardon, my lord, 538. So, paragraph 42, Lord Justice Popplewell makes some more general statements about the approach to statutory interpretation, which we've sidelined because, as you would expect from Lord Justice Popplewell, it's of value, but it's not the passage I specifically identify. The point about necessary implication is at 43, where a meaning is not set out expressly in the wording of the instrument. That meaning may nevertheless sometimes be implied. However, where the instrument is silent, the implication must be a necessary one, not one merely reasonable or desirable. This is well established by high authority, and he cites a number of cases, including Morgan Grenfell, which will be the last case I come to. And then after that italicised sort of group of cases, Lord Justice Popplewell takes it back up. The test is one of necessity, and what this means is that the implication must be compellingly clear, where he cites various other cases, including decisions of my lords, Lord Hamblin and Lord Burrows. And then at 44, he says, one reason for such an approach is that it's a relevant factor against making the implication. If it would have been easy enough for the instrument to have said it expressly but did not do so, and that's black, that's back to Lord Reid, the 1970s Lord Reid is cited. This is not a sufficient test in itself, but it means that, as Lord Justice Underhill put it in a previous case, it's a healthy principle that the court should be slow to give a statute in effect that is not expressly stated. Parliament should say what it means. And the court may recall that in his his concurring judgment, Lord Justice Stuart Smith said something quite similar in this case, that if Parliament wants to radically impact upon the assessment of damages not for whiplash injuries, then he doesn't put it as crudely as I'm about to, but he says in essence it needs to make a better fist of spelling it out than this statute addressed at whiplash injuries succeeds in doing, if I can paraphrase it in that way. So we say those principles are of some assistance. And lastly, so far as Morgan Grenfell itself is concerned, I know this is a case your lordships would have seen multiple times before, but well-known statements by Lord Hobhouse, which I was going to take the court to page 703. where his lordship says at paragraph 45, taking it up at the third line, the question therefore becomes whether there is a necessary implication. A necessary implication is not the same as a reasonable implication, and he cites Lord Hutton. A necessary implication is one which necessarily follows from the express provisions of the statute construed in their context. It distinguishes between what it would have been sensible or reasonable for Parliament to have included, or what Parliament would, if it had thought about it, probably have included, and what it is clear that the express language of the statute shows that the statute must have included. A necessary implication is a matter of express language and logic, not interpretation. And just before leaving that case, Mr Weir also cites paragraph 44 in support of a point we also make, but with reference to a different case. But I'll make it through the medium of the case my learned friend Mr Weir cites, since I'm in that case for other reasons. Paragraph 44, page 702, cites the celebrated statement of principle by Lord Hoffman about construing statutes which erode convention rights, with the well-known statement that the principle of legality means that that shouldn't be something that is divined from general or ambiguous words. But as Lord Hophouse says, after the indented quotation from Lord Hoffman, the context in which Lord Hoffman was speaking was human rights, but the principle of statutory construction is not new and has long been applied to the question of whether a statute is to be read as having overridden some basic tenet of the common law. Now, we say that that is a principle which does have some resonance in this case, if this is a case where the court is troubled by the meaning of the statute, although for reasons I'll come to momentarily, we say the court needn't be troubled. But if the court is troubled, and a process of painstaking interpretation is required, we say it is relevant that not only does the statute not address non-whiplash damages in any explicit way, but also that to take from those damages as well as whiplash damages the principle of full compensation or fair and reasonable compensation, to strip to make in that context what all three of us at the bar and the Court of Appeal all agreed was a radical incursion into the common law. And to do so not just in terms of the quantum of the recovery, but also the procedure of the recovery, to replace a nuanced judicial system where subjective factors are taken into account, with one where you just get a tariff with an extremely sort of camel and an eye of a needle facility to depart from it to the extent of 20%. To take that away from a claimant, in our respectful submission, is to impact upon some basic tenets of long-established common law principles. And again, without wishing to steal any thunder from my learned friends to the interveners, as they say, compensation for bodily injury is, amongst other things, a factor of citizens' rights to have their bodily integrity vindicated, even in small cases like this. And so we do say that to the extent your lordships visit the statute, or your ladyship visit the statute, and form the conclusion that in fact it's not obvious which party is right, that the principles which I've just sought to articulate are ones which support myself and my learned friend Mr Weir, and are again my learned friend Miss Hitching.
I mean, normally, as I understand it, that sort of approach to statutory interpretation is talking about what we might call constitutional fundamental rights. I'm not sure one would say amending the scheme for compensation for personal injury so that it works somewhat differently is infringing a constitutional fundamental right.
My Lord, you're obviously right to say that the ex parte Sims case, which is cited, is of that ilk, because as Lord Hobhouse says, it's talking about human rights. But as Lord Hobhouse goes on to say, it is applied more broadly. Because certainly there has been a tradition, and I know to some extent, of course, we've moved away as a community of lawyers and jurists away from sort of old canons of construction to a sort of more textured approach. But obviously, historically, historically there has also been an approach to other forms of legislation which abrogates rights of property, legislation which criminalises behaviour and such like, into tending to not to construe them more broadly than the express words require, unless that really is an essential implication for the statute to be effective. So I'm not sure. But I suppose what I'm saying is I wouldn't put it quite as high as your lordship puts it, and to say it's simply a matter of a constitutional type statute. I would say that when it does come to basic rights, the more the right appears to abrogate a settled right of the citizen, the more in my respectful submission, one would expect to see some unambiguous statutory.
I thought your point was more that it's not just reducing the amount of compensation, but it's taking away from Mr. Rabot and Mr. Briggs the ability to go to the court and say, this is what happened to me and this is what the effect of it has been on me, as
yes.
in my particular circumstances. And they just get the same amount of money that anybody would get,
yes.
rather than what the common law does, which is give a bespoke amount which is tailored to the effect of what has happened on this individual person. And that is something that's taking that away is something separate from the actual quantum
yes.
in pounds.
Well, my lady, I'm grateful for you for reminding me of that, because that's very much the reason why in our written case we do say it is not just about the quantum, it is also about the fundamental change in the procedure. And obviously I can't say that you lose your access to the court because you get to the district judge, but the district
It's
judge...
not so much the procedure, it's the making it a generic amount rather than an amount which reflects the courts having heard and assessed
yes.
what has happened to this individual.
Yes, yes. I mean, it is the substitute for a sort of substituting a Savile Row suit with a sort of with a sort of garment that you might have you might see a sort of Stone Age man wearing because it just sort of has a hole for his head and limbs, and that's about the extent of it. Can I then come on to the Act itself, which I'll take up at page 330. Obviously, my learned friend has crossed much of this ground already, but I do want to emphasise, perhaps to a greater extent than she did, just the extent to which it is addressed at damages for whiplash injury. Not just, in fact, in the parts that we visited, but some parts we haven't visited yet, because the Act also, for example, regulates the circumstances in which whiplash injuries can be settled at a pre-evidence stage. And again, we say those provisions also show very clearly that it is addressed at the whiplash. And if a case consists of a whiplash and something else, the Act itself is only addressing the whiplash and not the something else. So my learned friend invited attention already to the long title, an Act to make provision about whiplash claims. There is then the definition of whiplash injury, which is we've seen as a soft tissue to the injury back or shoulder. Can I perhaps, as I'm passing through it, deal with the exception? On certainly speaking for myself, like I think my learned friend Mr. Weir had proceeded on the assumption that must be referring to a connection which in some sense was an organic connection. I also, Mr. Weir gave the example of ribs. I thought of the sort of classic example where perhaps somebody suffers a bony injury to their shoulder as a result of very forceful seatbelt restraint. That will almost inevitably be associated with soft tissue injuries across their chest and sort of and probably a strain of their neck as well. And there obviously would be an organic connection. But obviously there is an expansive reading that would say that that exception is the solution to this case. But I have to be candid and say it's not the way in which Mr. Weir arrived.
No, I think when we saw section 3, it makes it clear that a temporal connection isn't enough.
Yes, yeah, I'm grateful. So, but just so there was, well, I need to say no more. So that's section 1. So far as Section 2 is concerned, that's essentially the Henry VIII power that allows the Lord Chancellor to amend the definition of whiplash injury. But even that power doesn't allow the Lord Chancellor to expand it beyond soft tissue to the back, the neck, back and shoulder. So it's a limit, though we have the spectre of Henry VIII. It's Henry VIII acting in a relatively confined area. Then the key provision, which is section 3, damages. You see, one says it applies to the determination by a court for damages for pain, suffering, loss of immunity where a qualifying whiplash has been suffered. So that is the gate. But then what we say, my learned friend said, is I think essentially it's common ground that 3.8 is the key provision. That's not the case at all. Our submission is that for present purposes 3.2 is the key provision and really is the answer, certainly to my learned friend's appeal. The amount of damages for pain, suffering and loss of immunity payable in respect of the whiplash injury is to be an amount specified in regulations made by the Lord Chancellor. So the only thing which the statute is controlling but via the enabling power to promulgate regulations is the amount that will be payable for the whiplash injury. Now, my learned friend kept modifying this to payable in respect of pain, suffering and loss of immunity caused by the whiplash injury. And that's a formulation she used repeatedly, but that is not the statutory formulation. What it controls is the damages in respect of the whiplash injury. Now, if you also suffer a non-whiplash injury, then your compensation for that is not controlled by subsection 2 in any way, and you are still entitled to compensation at common law for all the losses which are caused by that non-whiplash injury, even if they are concurrent. And I already made in opening, and I won't labour it, the proposition that there is nothing in subsection 2 to appropriate common symptoms to the whiplash injury alone, or deem them to be subject to the whiplash compensation alone, or to give the whiplash injury a precedence over the other injuries so that the compensation of the whiplash injury is deemed to compensate everything which is common. It doesn't do any of those things. It simply says the damages payable in respect of the whiplash injury is the prescribed amount. And what is, if you also have a knee injury, which is causing you pain and interfering with your ability to take out the bins or to play football or whatever it may be, that remains compensated at common law. And that is what we say really is the real, is where you really see the narrowness of the focus of this statute, and where we equally see that you can't possibly, in our respectful submission, say that by necessary implication, a statute which prescribes the damages payable in respect of the whiplash injury, by a side blow, as the Master of the Rolls would have it, has radically reduced the damages which are payable for non-whiplash injuries as well, because of the happenstance that they're suffered at the same time. What we then have, I think all of us have been skipping over a 3.3, which expands the prescription to minor psychological injuries as well. You might say that's telling where Parliament wants to expand the statute to regulate damages for something beyond whiplash injury. It does so very clearly, so you have that at 3. We can then skip over the rest of it until we come down to 3.8, which is the combined effects provision. And I'll park that, if I may, and just deal with it separately in a moment. But I'm not going to deal with it. But I just want to deal with that specifically in a moment. You then get to section 4. Which is perhaps of a slight background interest, which provides for a statutory review of the regulations after 3 years, which is, again, we would say, an indicator that Parliament appreciates that it's doing something that's quite experimental in this focus, in this context, and is perhaps another reason why one would not expect there to be unheralded interferences with matters other than whiplash injuries, absent that being spelt out. At 5.1, you have the facility to uplift the statutory award in limited circumstances.
Have we got a Lord Chancellor review so far?
I believe that I have seen references to it beginning to be embarked upon, but I don't think that we've got it yet because it will be this year. I think the coming into force was it May 2021? It was May 2021, so we're just coming up to the 3rd year, my Lord.
Thank you.
If they don't like whatever it is we do, there's an opportunity to change.
It may be that they have one or two other things on their plate across the road at the moment, but yes, your ladyship is obviously quite right. Yes. So the uplift in exceptional circumstances at 5. Well, A and B, again, are exclusively to address to whiplash injuries. 5.1c, again, deals with combined effect, and I'll come to the combined effect provisions separately. But then, if you then look at the gateway for giving an uplift for exceptional circumstances, which is at 5.2 on page 334, that again is addressed at whether the pain, suffering and loss of immunity caused by the whiplash injury makes it appropriate to allow a greater amount. For example, because the whiplash injury is exceptionally severe. So again, it's focused on that. And then the last provision, which I said I would show you, is this different provision about the rules against early settlement. That's subsection 6, which you have at the foot of page 334. Essentially, the way, my lords, my lady, this operates is it forbids regulated professionals from settling cases before a certain evidential stage is reached, and broadly that's having medical evidence. But again, this is all directed at the whiplash elements of whiplash claims. So you'll see that at 6.1, a regulated person is in breach of the section if he knows or has reason to suspect that a whiplash claim is being made, if he arranges or advises the doing of an act without first seeing appropriate evidence of the whiplash injury or injuries. So that is 6.1. And then at 6.6, the whiplash claim is defined. In this section, whiplash claim means a claim that consists only of, or so much of a claim as consists of, a claim for damages for pain, suffering and loss of immunity caused by one or more whiplash injuries. So the regulation of settlement is also exclusively addressed to the whiplash element of a whiplash claim.
What's the mischief behind this provision?
I will be. There are many people in this room that will know the market far better than I, but as I understand it, firstly, to prevent people advancing whiplash cases without any supportive evidence in the hope of procuring some settlement. But also, as I understand it, if I may be corrected from behind me, this is also intended, to, as I understand it, to protect claimants as well, because there have been instances, and I think at least one of them reached this court in a case about solicitors' liens, which I'm not sure whether I know my lady is aware of some of that litigation. I think two of them have, in fact, a case called Bott and a case called Gavin Edmondson, where defendants have been going around approaching claimants directly and trying to settle their cases, hoping to avoid paying legal costs. Now, of course, that doesn't arise in small claims because there are no legal costs, but I think it's perhaps also meant to address delinquency by a subset of defendants, but also claimants sort of trying it on without medical evidence. If I could.
It doesn't say that it's a regulated person is not able to mount a claim for a non-whiplash injury, even though they know that a whiplash injury has been suffered. So,
yes.
So it would still be possible for a regulated person to do that. But it does also mean that the claimant has to incur the cost, the unrecoverable cost, I think, of the medical report.
The medical report is recoverable, my lady.
Right.
Yes. You can recover. I mean, broadly speaking, you can recover the court fees if it goes to court. You can recover the fixed cost of the medical report, and if, for example, liability is in dispute and you have to pay to have a copy of the policeman's notebook if a police officer attended the scene, then you can get the cost of that. But in general, what you can't get are legal costs, so solicitors or counsel's fees. So if I can then, just before I leave the statute, just come back to the bits I skipped about combined effect. So I'll go back to 3.8. The first point to note about 3.8 in our submission is 3.8 is clearly unnecessary for the purposes of allowing the court to compensate injuries other than whiplash injuries. You don't need 3.8 for that, precisely because 3.2 is only controls damages payable in respect to the whiplash injury. So 3.8 is not there to preserve the court's power to compensate other injuries at common law, because that power is not otherwise abrogated. So it isn't there for that reason. So the function of 3.8, we say, is simply to make it clear that the Act doesn't prevent the court from making a compendious award for both tariff and non-tariff injuries. It doesn't say the court must make a compendious award. It simply makes it clear that the court can, if it chooses, make a compendious award that reflects both the tariff and non-tariff injury. And for that purpose, the significant effect, or the other significant effect which 3.8 has, it ensures that if that happens and the court does decide just to make a single compendious award for tariff and non-tariff, within that compendious award, the limitation on the whiplash element remains that imposed by the regulations. So when it says, so I've managed to navigate away from the page, when it says, yeah, thank you. Yes, sorry, it's because I hadn't highlighted. Yes, so when it says awarding an amount of damages for PSLA and loss of immunity that reflects the combined effect of the person's injuries, subject to the limits imposed by regulations under this section. That's a reference back to the regulations which were enabled by subsection 2 and subsection 3. Subsection 2, the regulations limiting what's payable in respect of the whiplash injury, and subsection 3 regulating what is payable in respect of the whiplash injury plus minor psychological injury. But so it preserves the statutory incursion in respect of the two scheme awards, but it doesn't impact on any way on the non-scheme awards. And again, going back to the point which I know doesn't improve by repetition, but going back to the proposition that if Parliament had intended to do what my learned friend says, Ms Hitching says it has done, if Parliament had wanted to, in this context, significantly reduce what is payable in respect of non-whiplash injuries because they happen to be suffered at the same occasion as the whiplash injury, then section 3.8 is a place at which it could very readily have done that. And that isn't a sort of glib or jury point, because as we've seen, Lord Justice Popplewell makes that very point in the case that I showed you a few moments ago when Parliament could have done it but didn't. That in itself is a speaking omission, if I can put it that way.
Could you just, I'm not quite sure I followed your submission. So what do you say 3.8 is doing that it has to do? Or perhaps put another way, if 3.8 were not there, what do you say would be missing on your analysis? Well,
the first point is it might be moot as to whether or not the court can make a compendious award, because there is a statutory tariff. So do you have to make an award of the tariff amount and then just deal with the common law assessment as a sort of second damages pot? But the key point is that that's maybe more in the nature for the avoidance of doubt provision, because it's not obvious to me that you would think you couldn't do that without 3.8. But what is probably vital for 3.8 is it does make clear that if you do make a compendious award, the element within the compendious award for the scheme injuries remains subject to the limits of the scheme. So if there is an award which contains a whiplash and a non-whiplash element, the whiplash element remains subject to the limits imposed by the regulation.
You might say, well, that would follow if that provision wasn't there anyway.
Sorry, forgive me.
You might say that would follow inevitably if that provision just wasn't there.
Well, you might say that, yes. Yes, for my part, I would say that it would.
Is your main submission that this is largely an avoidance of doubt?
Yes. Yes, and certainly, as you know, I've said it more than once, so and it throws emphasis on the fact that we say 3.2 is what matters here, not really 3.8. It's perhaps the most significant point about 3.8 is Parliament clearly is thinking about mixed injuries. I appreciate it's slightly inapt to talk about Parliament thinking, but forgive the shorthand, but doesn't make any stipulation of the sort that my learned friend has posited, notwithstanding, as I have submitted, that it is the sort of stipulation you might expect to see being made expressly.
One might say it's rather like subsection 9, which also begins, nothing in this section prevents.
Indeed.
And says what one might...
So you still have contrib, but except one would think it must be pretty obvious that you can still have contrib. But I suppose if that wasn't expressed, it might be argued that you didn't, but it would seem a pretty tough point to prevail on.
So the tariff can be reduced by contributory negligence.
It can be reduced by contributory negligence, but it can't, interestingly, be reduced at 3.8. It can't be reduced at 3.8 because you're compensating a mixed injury. So, insofar as is being suggested, there needs to be a Sadler-type adjustment. Well, and I appreciate I'm anticipating the cross-appeal slightly, but equally I've only got 20 minutes left. So, one of the points we make in support of there not being a Sadler-style adjustment is if the Act was anticipating that where there is some kind of compendious award, there would be an overall stepping back and an overall adjustment for proportionality. And well, that would require, we would say, a statutory facility to reduce the tariff award, but no such statutory facility is present. You can never reduce the statutory award. The only facility under Section 5, which we visited a few moments ago, is to increase it in exceptional circumstances by up to 20%.
And the odd thing about the Table A amounts is how specific they are. 15 to 18 months, £3,005.
Yes,
whereas as my understanding is that generally are awards more round numbers than that?
Well, as I understand it, what it might be, however, is these reforms were very long in gestation. I think as the Act itself, as you've seen, is 2018. The regulations are 2021. Whether or not the figures that were initially canvassed were updated with reference to the Consumer Prices Index or something like that, I suspect that might be an explanation, but I can't give chapter and verse on that. It might be that other people in court might know. But that's an explanation that occurred to me because the same point it seemed odd to me as well, and I wondered if that was the explanation.
Something similar used to happen when I did this sort of thing in the dark ages. You would go to Kemp and get a figure, and
you'd update it for inflation.
An inflation table.
Yes, so that's precisely how it used to be. I think Mr. Weir and I remember it well. So, in essence, the statute we say addressed to whiplash injuries, and that really is the key point in the case. Just seeing, I've anticipated a certain amount, so I'm skipping over a little bit of this. So far as the non-statutory materials are concerned, in our submission, I'm not for a moment suggesting they're not admissible resources, but we say, it's just a quick question, what do they really add? My learned friend referred to the explanatory notes, but the explanatory notes, we say, just reinforce the sense that the legislation is directed to whiplash injuries. There's no reference in the explanatory notes to damages for other sorts of injury of the sort you would think there might be if the statute was intended to operate as my learned friend and the Master of the Rolls would have it. I think my learned friend, for example, showed you page 982. Part 1 concerns claims for whiplash injuries where the duration of the injury does not exceed 2 years. It provides a definition of a whiplash injury which can be amended by regulations to set damages for PSLA arising from such injuries to a tariff. It also requires medical evidence to be obtained before a whiplash injury claim may be settled. And then perhaps a 986, I can't remember if my learned friend showed you that. At paragraph 17, she sidelined it, so she probably did. There are currently no legislative provisions that seek to regulate damages for pain, suffering and loss of immunity for road traffic accident-related whiplash injuries. Now, again, I would say that part of the fallacy in my learned friend's case is she reads references to regulating whiplash injuries as if it's a reference to regulating whiplash claims. But that isn't the way the statute is operating. The statute isn't directed to the claim, it's directed for the damages for the whiplash injury. And explanatory note 17, we say, reflects that. And to similar effect, 987, for example, at paragraph 27, the commentary on section 3. This section enables the Lord Chancellor to specify in regulations in the form of a tariff the damages that the court may award for pain, suffering and loss of immunity for whiplash injuries specified in section 1. Again, it is not whiplash claims, it is whiplash injuries. And certainly in the Court of Appeal, and with respect we say rightly, Lady Justice Nicola Davis, who surveys the travaux préparatoires at more leisure than I have, she demonstrates in my respectful submission convincingly that there is nothing whatsoever to support the defendant's argument, and yet the defendant's argument is something you would think would lead a pretty clear trail in travaux préparatoires if somebody legislating about whiplash injuries was also intending, in fact, to have a pretty radical impact on every injury suffered at the same time. My learned friend also relies on the regulations themselves. We respectfully say that they don't take the case any further either. They're at page 350. Because they too are directed at the damages payable in relation to the whiplash injuries, not the claims, the injuries. And then so one has that, for example, for the language of Regulation 2. The total amount of damages for PSLA payable in relation to one or more whiplash injuries is the figure specified. It doesn't relate to any other type of injury. So what then of the argument, which as I understand it, really is the argument of the Master of the Rolls, that despite none of this being spelled out, it arises inexorably, as he puts it, by necessary implication. Well, we say, with respect to his lordship, obviously not, because the analysis we commend leaves the Act working perfectly robustly. Firstly, damages for the whiplash injury are still suppressed to the statutory tariff, which, as we have seen, is a reduction in the smallest cases by about 90%, and even in the biggest cases of about 50%. As it's also been said, this is common ground. The legislation needs to be looked at as a package, and as a package, at least as financially significant, one suspects more financially significant, is the liberation of defendants from paying legal costs. And without going into the technicalities of it, we address this in a certain amount of detail in our written case at paragraph 49. But the effect of shifting these cases en masse from the fast track, which is my learned friend, I think, accepted, before these reforms, almost every personal injury case was off the small claims track. You basically had to, but under the JSB guideline, as they were, the JCG, so Judicial College Guidelines, to get common law compensation of more than £1,000, you had to get off the small claims track. You had to show symptoms of maybe a couple of weeks. So nearly every case is not a small claim. Now, nearly the vast majority of road traffic cases are now small claims. And the impact of that is in fact far more significant potentially than the impacts of damages, because as we say in paragraph 49 of our case, even post the Jackson reforms, the costs recoverable in fast-track cases may be several £1,000s. And now they will probably be reduced by something of a factor of certainly well over 90%, because all you get is the medical report fee and the court fee if there is one. And of course you only get the court fee if it doesn't settle. There was a certain amount of discussion about whether or not one can have regard to what has actually happened. And I appreciate the answer to that is that maybe much more a matter for the Minister in his review than it is for a court of law. But nevertheless, as my learned friend showed you the explanatory notes to the Act, I don't ask you to turn them up again, but it was the passage she read to you, that at the point the Act was introduced, there were 650,000 road traffic claims a year. That was 2017, page 983 of the explanatory notes. The figures that my learned friends herself or her solicitors themselves filed for the purposes, as she explained today, of getting permission to appeal, reveals that the most recent figures, this is at page 1578, show that for the last quarter of those figures there were about 67,000 claims. So obviously 67,000 over 3 months annualises to about 270,000. So I appreciate, and I don't claim it's an exact remark because of course there are some road traffic cases which won't be small claims even now, but it will be a tiny minority. 650,000 when the Act is introduced, on my learned friend's own PTA figures down to 270,000. So to suggest that what Mr Weir and I are commending to this court is a sort of evisceration of the statute, in our respectful submission, is misplaced. We address that in some detail in our written case, and I adopt it without repeating it. My Lord, so far as the case against us is concerned, I don't have time to subject the Master of the Rolls' judgment to any lengthy oral critique. He really gives 7 reasons from paragraph 63 of his judgment, but really nearly all of the reasons are premised on his second reason, and perhaps that is therefore the one which I should turn up, and that's at page 176. Paragraph 64. And it's in this passage that he starts by adopting the same position that my Lord Burroughs put to my learned friend when she adopted was a misplaced position, which he leaps immediately to emphasise the words "is to be." But as we say in our written case, and with respect, he would not have fallen into the area he did if he'd also added an emboldened emphasis to the words "in respect of the whiplash injury," because that is what he simply leaped over those words. He says that the judge has made a specific finding on the evidence the additional injuries did not cause any loss of immunity that was not also caused by the whiplash injury. The statute therefore provides that the amount of damages for the loss of immunity caused by the whiplash injury is a tariff amount. Well, with respect, again, that is precisely the fallacy of my learned friend's submission. It treats the statutory language as controlling the damages for losses of immunities which are caused by the whiplash, even if they're also caused by other things. But that is not the statutory language. The statutory language is that it prescribes the amount to be payable in respect of the whiplash injury. It doesn't in any sense reduce what is to be paid at common law in respect of other injuries which cause the same losses, nor does it appropriate the concurrent symptoms or losses of immunity to the whiplash injury, nor does it privilege the whiplash injury over any other species of injury. And if we're right about that, then with respect, we say the Master of the Rolls' analysis simply falls apart, because he goes on to say the claimant cannot claim compensation for the same loss of immunity caused by another injury on a different common law basis. Well, we say yes, he can, because that's the very thing which 3.2 preserves in saying it only controls what you are paid as damages for the whiplash. He's wrong to say the statute has dictated the compensation that is to be paid for that very loss. The very loss the statute controls is the damages payable for the whiplash injury. It doesn't control the damages at common law, which remain larger, and therefore the compensation of anything concurrently caused or exclusively caused by the non-whiplash injury remains at large and at common law. Seeking more would violate section 3.2. It would not violate section 3.2 because section 3.2 relates only to the damages which are prescribed for the whiplash injury and not for anything else. So that's our respectful critique of the Master of the Rolls, and essentially my learned friend, as will have been obvious from that argument, really adopts what the Master of the Rolls says, and we respectfully say makes the same mistakes. So, my lords, my lady, those are the reasons why we say my learned friend's appeal fails. The Act does not control compensation paid for anything apart from whiplash injuries, and therefore there being no challenge, for example, in the Rabot case, to the learned district judge's assessment that the non-whiplash injuries caused damages compensable at common law by £2,500, and then we have the amount that's allowed in Briggs. That simply does not fall to be reduced because of the statutory award. That's also in our submission. Leads to a coherent outcome. Because what is payable in respect of a knee injury or whatever it may be is not being suppressed by the happenstance of a whiplash injury being suffered at the same time, notwithstanding the fact that, as I have sought to show, the Act is not addressed to non-whiplash injuries. On the face of it, and it's the point Lord Justice Stuart Smith makes in a, if I can respectfully say so, a very muscular concurring judgment at the expense of the dissenting judgment, says, well, the Master of the Rolls, he begins by accepting that this is a judgment, a statute which is addressed at whiplash injuries, and then he goes on to find that it, by a side blow, has massively reduced damages for non-whiplash injuries, and that can't be right. And respectfully, we say, yes, that is right, without in any sense suggesting that my Lord the President was testing the point rather than deciding it. It was also the point which my Lord the President put to my learned friend, isn't it? Essentially a very curious outcome that by a side wind, the happenstance of a non-whiplash injury being suffered with a whiplash injury leads to you getting less for the conjunction of injuries than outside the Act you would have got for the non-whiplash injury alone.
Are you going to address us as between your primary and your secondary?
Yes, I'm just about to in the few minutes that I have left, so thank you. Take my primary case first, that the Court of Appeal was wrong to apply a Sadler adjustment. Essentially, we say that's misplaced because it attempts to combine two sorts of awards calculated with reference to different criteria. And the defendants themselves make this point very forcibly at paragraph 68 of their written case, which is at page 109, where they say it is unprincipled and ineffective to try to address what they characterise as overcompensation and double recovery by a stepping back exercise, because the common law and statutory tariff value the concurrently caused PSLA differently. The common law seeks to place a value on such damages which is fair, reasonable and just, and the statutory tariff has set the value of such damages with reference to proportionality. So a Sadler approach cannot work as a matter of principle, as the potential double counting is non-commensurate. Well, we disagree with that, but of course we come to a different conclusion because we say that the defendant's argument is premised on their antecedent misreading of the statute. But once you correct that, you're left with there being a tariff award, which is calculated, as they've rightly said, on an utterly different basis than the common law award. And combining them is to combine, I think Mr. Weir gives the hallowed comparison of apples and pears, and it may be because of the difference in quantum we should perhaps be talking about apples and nutmegs or something of that sort, but you are combining things which are just different, at the risk of creating a sort of Frankenstein's monster in a way we say that you don't need. That is a position
is that right? Are they so different? It looked as if the first instance judge managed to make what on the face of it seemed a pretty sensible deduction on the face of it. You might say that the statutory tariff is a form of compensation.
Yes.
It's clearly a reduction on what the common law would offer, but it isn't actually apples and pears at all. It's just, if you like, smaller apples.
Well, first of all, my lord, may I thank you, because you've just encapsulated my alternative case, my secondary case, if I can respectfully say so, far better than I could, and essentially that will stand. I would adopt that as my submission on my secondary case to save some time in a few moments. But as to why I would respectfully differ from it on my primary case, I do say that it isn't just a question of a smaller apple. It is a question of something which is actually different, because as the defendant himself has just granted in the passage I've read, it is firstly something which is determined with reference to a different criterion, namely supposed proportionality, rather than the common law principle of full compensation. And second,
where do we get that proportionality idea from?
I think my learned friend takes it from the explanatory notes. I think that will give you the reference before we rise. But
it is kind of following up with my Lord Borough's point. It is Parliament's assessment of what's fair, just, and reasonable, but taking into account all sorts of other factors like the need to reduce motor insurance premiums and the risks of fraud, which are not factors which are taken into account in the common law assessment. Yes,
and it takes into account the interests of defendants. And of course, the common law, I think there's express decision of, that says the position of the defendant's got nothing to do with it from the common law perspective. But the parliamentary perspective is that, well, we need to establish essentially a different equilibrium between the competing interests of wrongdoers and their victims. So that's why we do say it is a different exercise, and of course it's also, again, the earlier debate I had with my lady, it also is of course the product of a different exercise. It's not the tailored award which has been previously debated, and that therefore is in our submission to be contrasted from a conventional Sadler adjustment, where you are reconciling various elements of a common law award to ensure the overall figure reflects an amount which is greater, equal, or less than the sum of the parts. And also the concern in a Sadler context, the sort of underpinning concern of the common law in making adjustments is to make sure there's consistency, predictability, and consistent predictability between awards for different injuries, but nevertheless of a similar sort of severity. So you don't get much more for sort of 6 months of a sore neck than you do for 6 months of a sore leg. But those are considerations that, again, they don't apply in this context, because you aren't comparing apples and pears. And in fact, Parliament has decided you do get much less for 6 months of a sore neck than you get for 6 months of a sore leg. So you don't run any risk in this context of awards which are out of kilter with other common law awards. Also for the practical reason that, because within that award is a statutory element which is far lower than the common law would allow. We would also say that there is, I suppose it's an objection where the Master of the Roll says he was ill at ease with the majority's approach because it's insufficiently scientific. Now, where a judge giving a single common law award of common law damages makes a Sadler adjustment, that judge obviously knows very well the factors he or she has taken into account in composing the award, if I can put it that way. That judge is in no place at all to know, well, what factors have been taken into account in the statutory tariff element of the award, because they are just completely impermeable. It isn't something which one can indicate. So how can one adjust when you don't have the moving parts which allow an adjustment, all in circumstances where, as I noticed earlier, the statute doesn't allow the tariff amount to be adjusted in the way you might think that it would if there was an anticipation that in the case of compendious injury there would be a sort of Sadler exercise.
Mr. Williams, I think you're eating somewhat into Mr. Weir.
Mr. Weir and I do have a sort of concordat, but I think I'm well corrected, if I may say so. So can I just say, in terms of, if I'm wrong about that, and I'm defending the intermediate approach of the Court of Appeal, and without it, I hope being thought it's sycophantic, I can't improve the way that my Lord Borough encapsulated just now. So if you're against me on my primary point, I invite you to be with me on my secondary point for the words that Lord Borough's kindly ventriloquised. Grateful.
Thank you very much, Mr. Williams. Mr. Weir.
Please, my Lord. President, my lady, the Lords. The proportionate reference is page 983, paragraph 7 of the explanatory notes. My Lord, I've 5 submissions to make in support of the intervener's case, which is going to set out now. The first is the Act has provided the exclusive remedy for the whiplash injury. In so doing, it has removed the whiplash injury from the court's common law assessment of damages for the non-whiplash injury. Second submission is the Act has only provided an exclusive remedy for the assessment of damages in relation to the whiplash injuries, that's section 3.2. And by that subsection, it has in no way extended the ambit of its operation to the assessment of damages in relation to the non-whiplash injury. Third submission is that the Act and regulations do not provide the claimants with full compensation. And I'll actually put the words full in brackets. I know my Lord Barrow says, well, it is compensation. Said query compensation at all, certainly not full compensation. That rather depends on what is understood by the word compensation, which may be a
Paragraph 7 that you've referred us to talks about proportionate amount of compensation.
It does, my Lord. It does. In the explanatory, I readily accept that. But that does not mean that it constitutes compensation as this court understands the term. It depends on what this court understands by the meaning of the term compensation. And that's certainly not full compensation for the effects of the whiplash injury. So I'll just repeat that. The Act and regulations do not provide the claimant with full compensation for the effects of the whiplash injury. So the principle of full compensation in respect of the non-whiplash injury is entirely unaffected by the Act. There's nothing to set off against it relevantly because the Act has not provided full compensation for the whiplash injury. And the qualified principle of double recovery is not engaged. Fourthly, and in a slight departure from my learned friend Mr. Williams, Parliament has spoken by section 3.8 and expressly addressed the issue before this court and come down in favour of the court assessing damages at common law for all the effects of the non-whiplash injury. So we say section 3.8 does more than learned friend Mr. Williams says it does. And finally, the defendant's proposed interpretation of the Act cannot be correct having regard to the consequences that would flow. So I turn to the first submission I was making, which is that the Act has provided the exclusive remedy for the whiplash injury, and in so doing, it has removed the whiplash injury from the court's common law assessment of damages for pain, suffering, loss of immunity in respect of the non-whiplash injury. And for that submission, I'm going to pick up the position, the Act having been put on the statute first. But before that, by way of preamble to address an issue which has interested the court in relation to the so-called Sadler assessment. So before that, we have the common law. And can I briefly seek to respond to observations of the court in relation to what is required in a Sadler assessment? And the short answer is, it is as broad as it gets, really by reference to an ordinary understanding of what the Judicial College guidelines are seeking to do when they set figures or brackets for an injury, much more than it is by reference to the individual circumstances of a case. It's that broad brush, and to also seek to make good what I mean by that. If you have a knee injury on its own, And the judicial college guidelines say this is worth about £2,250, which is up to 6 to 7 months of knee injury. The reason they've got to that figure, and they've done this translation from the intangible to pound, shilling and pence, is that it's understood that a knee injury for up to 6 to 7 months is liable to cause a degree of pain and suffering, some difficulty walking, and all that comes with walking for a window of time. And you get it. That's how they've reached this figure of £2,250. And you could have another injury, be it a pre-act whiplash injury or an elbow injury, when it might be said for 6 to 7 months, let's just say £2,500, which of course is more sympathetic to the effects of an elbow because we use our hands as much as we do. And if you have those two injuries 2 years apart, you may expect, broadly speaking, to get £2,250 and £2,500. If on one occasion you have both injuries, the courts understand that it is not so bad. It is not so bad because you only went to hospital once. You went to your GP once. You're probably off work for a little window. You're off work once for that little window. So your life has been interrupted. You've had what I loosely call upset for a single window of, say, 6 to 7 months. And that is not as bad as having two separate accidents 2 years apart. And so the courts look at those two figures and they say 2,500, 2,250, I got my arithmetic correctly, 4,750. And then it's really like this. This is from the experience of doing, as I remember, about 900 whiplash cases in the space of about 3.5 years, because they were recorded, all for one firm of solicitors, by number. And I remember getting to the number 900. It's as broad as saying that feels like about 4,000. Because there's overlap. It's not overlap super specific to the claimant. You don't worry about overlap in that way. It's because each award contains within it an element for the fact you've been injured and upset and put out of place. That's the principal way in which the Sadler operates. That's why it says you step back and look broadly at the matter. And there will be occasions, if you have a scar, a woman with a scar on your face, additional to the other injuries, you may get full compensation for the scar, which I mean the Judicial College Guidelines award for the scar, because it truly is additional to the general effect of, it could be one or multiple series of other injuries around your body. But it works as broad as that. It is a country mile from that which is being suggested should be now the system for the defendant's submissions.
So just to break that down, do I understand you therefore to be saying that it's essentially objective in the way I was putting it before, that is non-specific to particular characteristics of this claimant in the broad brush approach?
What happens is, that knee injury caused that person to stop playing football. They love their football. The football was massive to them. 2,250 goes up to £2,600 because the witness was very persuasive about how upset they were about their inability to achieve that sporting activity. But we now look at the £2,600 plus the £2,500, we say £5,100, and now we go 4.5. That's the way in which it's done. It's really that shrug of the shoulders, that decision. That's how justice is put through the system in a proportionate and effective manner under the Sadler system. And in relation to the issue of juror and Sadler, there is no difference between juror and Sadler. They are not jurors, my learned friend Miss Hitchin says, and Sadler, two different systems at all. They are not two different systems. You may have a big injury and a small injury, you do the same thing. It might be £4,000 and £1,000. £5,000 feels like 4,750 in that case, or whatever it feels like. But it's just the same system. What my learned friend for the defendant is actually doing when you come to the pound, shilling and pence in this case, is they have snuck in, under the radar, a new system of interpretation, which says that the common law assessment of non-whiplash damages should be in proportion to the tariff award. My only friend, Mr. Williams, says he doesn't know how they've got to the figure of £465. Respectfully, we think we do know how they got to the figure of £465, because absent £5, it is a third of the figure of £1,390 in the Rabot case. So £1,390 is the whiplash award, and they've taken a third of the whiplash award and said we'll add that on. And that is simply incoherent legally, because it must be accepted, and it is accepted by the defendant, that the assessment of non-whiplash damages proceeds on a common law basis. Whether you take out the overlap or don't take out the overlap, it proceeds on a common law basis, which can therefore have no regard for the statutory tariff award. But that's what they've been doing, and that's why you end up with these remarkably low figures. And I then go back to my first point. My first point is simply to set the correct scene. The correct scene is, and this is obviously trite, but really important, this Act has removed the common law remedy of pain, suffering, loss of amenity for whiplash. I'm not going to keep saying qualifying whiplash, it's whiplash injury, removed it and replaced it with a statutory tariff scheme. But another way, it's provided the exclusive remedy for the whiplash injury. And the significance of this, for these purposes, is that the common law assessment of damages, which must still take place where a claimant also suffers a non-whiplash injury, prima facie will not take into account the whiplash injury. It's been removed from the common law. So that is the starting position, we say the end position. Namely, the whiplash having been removed from the common law arena, the court should assess damages for pain and suffering for the non-whiplash injury, disregarding the effects of the whiplash injury. That means, in the context of this appeal, disregarding whether the whiplash injury is also a cause of some of the effects of the non-whiplash injury. Now, clearly, some statutes have an effect so broad that they impact upon common law rights or remedies, for which a paradigm, a number of cases, is the Water Industries Act in the famous case of Marchich in the House of Lords. And that was a comprehensive statutory scheme which replaced the law of nuisance. Well, it's one, and there are many, my lord, working examples of this. And as my learned friend, Mr. Williams, wrote in there, my learned friend Mr. Williams has already submitted. This Act is not such a scheme. It's a super limited scheme. So,
I mean, no doubt you'll come to this, but the Act doesn't tell us to, doesn't tell the court to disregard the whiplash injury when awarding damages, when deciding on the amount of damages for the other injuries. It says in section 3.8, to an award an amount of damages that reflects the combined effect.
My lord, yes, that's section 3.8, which I can take out of turn.
But you take it in your own way.
That's really important to get
But
to. Before that, I was just saying, I recognise that there are some statutes that I've said, I sort of set the correct scene. The correct scene is that the common law now has had the whiplash removed. There are some acts which, in removing it, have this sort of earthquake-like effect on the common law, and that's why we have to look at whether it does. And my second submission is a poor echo of the submissions made on Mr. Williams, which is that the Act has only provided an exclusive remedy for pain and suffering in relation to the whiplash injury. Now, it's clear that the defendant hangs its hat, as did the Master of the Rolls, on the wording of section 3.2. And it would also appear to be common ground that the defendant is seeking to establish that Parliament intended to and achieved the outcome that the statutory tariff award provides the exclusive remedy, not just for the whiplash injury, but also for the effects of the non-whiplash injury, which overlap with the effects of the whiplash injury. That's what they're saying. That is the effect of the injury. In circumstances where it is common ground, there is no express wording in the statute to support the defendant's case. And the defendant is having to establish that section 3 to achieve this outcome by necessary implication. and see what that means in the passages that Mr. Williams has taken the court to already. When addressing the issue of interpretation, it is also relevant to have in mind that the defendant is contending that Parliament has deliberately cut down the claimant's right to recover damages for pain and suffering at amenity for the non-whiplash injury in circumstances where the claimant's right to recover damages for the non-whiplash injury is the means by which the tort law protects the claimant's right to bodily integrity. And we don't have to say this has or has not triggered the principle of legality for this to be a point of significance. And see our written submissions, paragraphs 4 to 7, pages 139 to 140, in which a combination of Lady Justice Hurley Honorary and Dyson make clear, however big or small, the award of damages for personal injuries is the means or mechanism by which the court respects an individual's right to bodily integrity. Furthermore, the effect on the claimant's right to recover damages, if the defendant is correct, is profound. You'll see reference to the figures. So that the defendant has the unenviable task of establishing that such a profound intrusion into the claimant's common law right to damages must flow logically, by necessary implications, from the words is to be. That's it. Whereas is to be is simply section 3.2 performing a very ordinary statutory task. Section 3.1 says this is what we're looking at. Section 3.2 says this is what we're going to do. That's it. That's is to be. It's just saying take out whiplash, pain, suffering, loss of immunity, whatever you thought it was, it is now to be this, a statutory task. So in circumstances where the Act itself addresses only whiplash injury, and the mischief at which the Act is aimed relates only to whiplash injuries, not to non-whiplash injuries, the ambit of the Act is clearly so limited. My third submission is one which proceeds on the basis that the court needs to go further. In other words, if, contrary to those submissions, the court needs to go further, then in any event, the Act and regulations do not provide the claimant with full compensation for the effects of the whiplash injury, so the principle of full compensation in relation to the non-whiplash injury is entirely unaffected by the Act. And the qualified principle against double recovery is not engaged. Now, it's a necessary step in the defendant's submission, and we see this, I'll just give you their reference. It's paragraph 22 at page 95, and paragraph 54D at page 105. It's a necessary step in the defendant's submission that the claimant has been fully compensated for the effects of the whiplash injury by the statutory tariff award. And that's how they say the principle against double recovery is engaged, so that the court must interpret the Act preventing the court providing damages at common law for an acknowledged effect of the non-whiplash injury in order not to offend against the principle against double recovery. Can I make 5 submissions in response? First is, the statutory tariff award does not provide, brackets full, close brackets, certainly full compensation. It's common ground that the statutory tariff award is radically lower than the common law assessment of damages. And my learned section opened on that basis and see her case in paragraph 4, page 91. Furthermore, that the statutory tariff award is made by reference only to the duration of injury, and that the tariff award does not have regard to the actual effects of the whiplash injury other than in relation to duration. Note the continued reference to the word effect, which is why I address these submissions before I come to section 3.8. It does not have regard to the effects. See the observation by Lady Rose. The statutory tariff just says, it lasted for 3 months, this is what you get. So it does not purport to compensate the individual claimant for his or her individual loss of amenity. It does not observe the principle of full compensation.
But it is giving an award for pain, suffering and loss of amenity. It is not saying we're abolishing damages for whiplash. We are replacing it by a statutory scheme whereby a fixed sum is going to be applied for whiplash, for the whiplash injury. Then I could see that you would have no easy linkage between common law damages and it might be, it's almost like a social security scheme or something. But that's not what we got. They're still saying that we're looking at pain, suffering and loss of amenity.
Well, what they're saying is, this is the common law. The common law gives you an award of damages for pain, suffering, loss of amenity. That is existing at the time the Act comes in, or up until the time the Act comes in, section 3.2. And the amount for that is to be. So you had that, you don't have that anymore. That has gone. This is part of extinguishing the remedy of damages for pain, suffering, and loss of amenity from the common law. This is my first submission. That is what it is doing. Reading section 3.2 does not allow you to understand that there is compensation in that sense. And this turns
But I think your submission leads to the view that it is impossible to see there as being any overlap on pain, suffering and loss of amenity.
My Lord, it is impossible to see there is any overlap as to the effects of the injury. For overlap to make relevant sense in this context, the defendant is saying you have suffered effects of your knee injury. The example I used in was badminton. Stick to that if I may. You can't play badminton because of your knee. You also can't play badminton because of your neck. The position here is you can't play badminton because of your knee injury. You should be compensated for that in a normal way. Either way, before the Act came into force, you suffered a whiplash injury, the effects of which included loss of ability to play badminton. The entire business of pain, suffering, loss of amenity in relation to the whiplash has been removed from the common law and placed in a statutory tariff that has no regard to the claimant's circumstances. None other than...
So I'll put to you again, it is impossible on your submission to see any possible overlap.
My Lord, yes, any possible relevant overlap. There's overlap in the sense of, is there a whiplash injury which has prevented you
overlap
from
in terms of pain, suffering and loss of amenity.
It's not even pain, it's a statutory tariff award.
Yeah, so it is impossible on your submission for there to be any overlap of pain, suffering and loss of amenity.
My Lord, yes, it's impossible. Relevantly for the purposes of whether you should then set off against the non-whiplash common law award of damages. Absolutely.
Yeah.
Absolutely.
Whereas I think what the case being put against you and what it might be said the majority in the Court of Appeal are saying is, well, clearly the compensation has been very significantly reduced, but we can sometimes see that there is bound to be some overlap, and therefore, in principle, one needs to accept this potential deduction.
That is indeed what the majority of the Court of Appeal said, my Lord, and respectfully, it so cannot be right. And my learned friend, Ms. Hitchin, essentially agrees with that. See the passage which my learned friend, Mr. Williams, just read out from her written case, in which she put it very attractively, page 110. A Sadler approach, therefore, cannot work as a matter of principle, as the potential double counting it is seeking to address is non-commensurate.
But I'm putting to you, it is commensurate.
On what possible basis can it be said to be commensurate? You have pain, suffering, loss of immunity, which is bespoke damages for an individual's pain, suffering and loss of amenity at common law. And then you have a replacement, an extinguishment of that remedy, and it being replaced with a statutory tariff award that has no regard to the plaintiff's pain, suffering and loss of amenity, other than by reference to duration. That's why I say it's apples and pears. And if one just for one moment opens that door and wonders how it is that someone's supposed to make the so-called Sadler assessment when you don't have something to compare it to, because you are dealing with Sadler assessment is to avoid double recovery in the context of an environment in which you're seeking to effect full compensation. And you're now seeking to set off against what would otherwise be full compensation, which is recovery of damages for loss of ability to play badminton as a result of the knee, a statutory tariff award which has no regard, none, to whether or not that claimant played badminton or not. None.
But the common law guidelines also are affected by the duration of the injury. So there is some... For a claimant who never played badminton or football, who doesn't suffer that kind of specific loss of amenity, would you say there is overlap in their case, or not even there?
There isn't overlap. There is not overlap. The real force of this point comes from an observation of my Lord President. By actually running this one through to what if the effect of the Act was to say there is no damages for whiplash injury, because actually logically it's the same position. It just doesn't matter. It doesn't matter now if you take it down to nil. There's no difference between giving me £960 for whiplash when you don't have regard to my circumstances and asking me somehow, fancifully, to play a Sadler game with my £2,500 knee injury and a radically suppressed, non-bespoke statutory tariff award. It's a game. You're literally just inviting the court to say, well, that 2,500, this one looks a bit low, do I knock it down a lot because that one's quite low? You're just not measuring against a rubric of seeking to achieve full compensation, because the thing you're seeking to set off expressly does not achieve full compensation in order to accord with the parliamentary objective.
Well, the explanatory memorandum we were taken to tells us effectively that Parliament, well, the government thought, and the Parliament has endorsed the view, that the awards made by the courts were disproportionate to the level of injury suffered and had been replaced with a proportionate level of compensation. And it's rough and ready, it's not tailored to individual circumstances, because we're talking about amounts of money, it's hardly 1 hour of a solicitor's time, so it's kept very simple.
Well, it isn't full compensation. The use of the word proportionate in the explanatory memorandum cannot save the day. They cannot hang their hat on that, because it is what it is, and it is not what it is not. It is not full compensation. We reference the McGregor on damages, which divides up damages into compensatory and non-compensatory damages, and has liquidated damages as non-compensatory. That's my submission. It rather depends on how you view the word compensation, which I struggled with before I found that passage to articulate it. But certainly this could be compared to under-liquidated damages. And under-liquidated damages on any view are not compensatory.
So in our case, we know that the District Judge Hennessy did carry out this Sadler adjustment, and the Court of Appeal also did it. The Court of Appeal did it by stressing that in doing the Sadler adjustment, one has to bear in mind that, of course, the damages for the whiplash injury have been reduced by Parliament. So in a sense that was a sort of marginal modification, if you like, of Sadler. But are you suggesting that the answers they came up with are just illogical and impossible to explain?
They literally cannot be supported. You can't do it. The whole point of Sadler is you're seeking full compensation. You're not doing anything else. You're not just saying, I've got something over here, I've got something over here, and I'm going to mix them up in some way that is completely unprincipled.
But isn't that what, I know you're coming to section 3.8, isn't that what section 3.8 is getting at? That you can give an overall award, that this new regime doesn't require district judges to get more specific about exactly what they're awarding for exactly which ache and pain. But what you mustn't do, it's saying, is add on a bit for the non-whiplash injury because you think that the tariff is too low for the whiplash injury. You've still got to bear in mind the tariff for the whiplash injury and not bump up the other in order to arrive at what you would have thought was a fair result, absent the tariff. Isn't that what it's warning against?
With great respect, that simply isn't reflected in the language we use in section 3.8, I guess how I would put it. If we go to language in section 3.8 and see what it actually does. Starting with I'm going to have to park those other submissions in relation to you have the force of sense of the submission I'm seeking to make, but I'm going to move on just for time. If you go to page 333, please, to section 3.8, we recognise that it starts, as my Lord readers observed already, as per section 3.9, with nothing in this section prevents. And nothing in this section prevents is like, as has already been observed by the court, a holding provision. And the holding provision is the status quo ante, which I sought to set out by my first submission, which is, prima facie, the common law assessment of damages for non-whiplash injury is unaffected. So that's the correct starting position. And we're not seeking for some bumping up or uplift on that, but that's the starting position.
And so, I don't know, it could be described, I suppose, as a sort of saving provision. But where a person suffers, and then Parliament expressly addresses the so-called mixed injuries cases. So this is crucial, because Parliament is expressly now considering this issue. And what is the language which it uses? Well, first of all, it says, nothing prevents a court awarding an amount of damages. Now, the amount of damages must be the amount overall, because it's an amount of damages that reflects the combined effect of the person's injuries, subject to the limits imposed by regulations under this section. But what is the moving part? The only moving part in this is damages for the non-whiplash injury. It's all agreed that that in brackets merely rehearses that which section 3.2 provides, which is you cannot touch the statutory tariff. So Parliament is addressing its attention necessarily to the court's role. Nothing in this section prevents a court, not in relation to statutory tariff, because that is fixed by the regulations, and therefore only in relation to damages for the non-whiplash injury. And the language which it uses is awarding an amount of damages that reflects the combined effect of the person's injuries. The tariff has nothing to do with the effect. See the submissions I've already made. So this is saying the combined effect. In other words, even if it is an effect due to the whiplash injury as well as the non-whiplash injury, you can recover for it when making your claim for damages for the non-whiplash injury. So you could also say for all the effects of what it calls the injury at the beginning of sub 8, but we'll call the non-whiplash injury. So that's why we say section 3.8 does more than has been submitted to you so far. We say it provides the answer, and not in a way of saying please don't add on a bit more just because you're a bit upset that the tariff is down. It just says simply compensate the claimant fully for the effects of the non-whiplash injury, even if those effects are combined, in other words, combined with the whiplash injury. That might be synergistically combined, it might just be by way of overlap. But that's what Parliament is doing. Otherwise, there is no substance to Section 3.8. And we do refer to, and I won't have time to go through it, but I would invite the court to look at the case of Vernon and Bosley at page 861. It's a very interesting passage from Lord Justice Evans, because actually if you follow the observation of my Lord the President, that we could as well be dealing with a scheme in which it says there's no damages for whiplash. When you're dealing with a claim for psychiatric injury resulting from a shocking experience, without wanting to go to my shocking experience in relation to the secondary victim claims, but just staying with this issue, when you, as the law was understood at the time, when you're going to a shocking claim, provided you can track through that causes you a recognisable psychiatric injury, you can claim for its full effects, even though what you have may be described as pathological grief disorder, in other words, an extreme effect of grief, where grief cannot be compensated. And the cannot be compensated materially is akin to the position of the statutory tariff, not least if you take it down to a nil award. But the principle that underlies it is the same, and see the careful analysis of Lord Justice Evans, including an analysis of the practical consequences of it flow if you had to do it otherwise, in terms of further investigation, exactly as per the submissions we make in this case.
You may be able to answer this. If you had a fatal accidents claim for bereavement and suffered the pathological grief reaction.
You get your full pathological grief reaction. Everyone gets their £13,800 or $1,500, whatever it is now.
Right.
Who qualifies?
Yeah.
Spouse, say.
Yeah. Yeah.
You get that. That's.
Is there any authority on that?
I don't know, but I just so feel that must be right. There's not enough for me to tell you that, but that is something separate. That's the point. Again, it has no regard, deliberately, Parliament decision, no regard to your grief. You may hate your spouse and be thrilled that he or she has died. You still get the award. If you have a pathological grief reaction, I would say the closest authority, having looked up that issue, is the Vernon and Bosley analysis of Lord Justice Evans, which is absolutely gets to the nub of the point. Because what you're looking at is saying, I must compensate the claimant for their non-whiplash injury. It's why it's a sort of two-stage process when we come to looking at this issue of betterment or avoiding double recovery. The first task of the court is to achieve that full compensation. The second stage is say, what do I do with a statutory tariff award? And you've heard my submissions already in relation to that, which is the apples and pears submission. You cannot start the game of trying to set that off, or you engage in a completely artificial and unprincipled exercise. And then finally, in relation to Section 3, I'd make the same point which has already been made, but the wording we use, for instance, is if this Act was here to exclude the overlapping effects of a non-whiplash injury. This may not be well drafted, but it could have just said, in a case where a person suffers an injury, in addition to the whiplash injury, damages for pain and suffering for loss and immunity for such injury shall not include any pain, suffering, loss of immunity also attributable to the whiplash injury. Full stop. I mean, that's the defendant's case as to the effect of the Act, and it is completely absent. That's why they seek to simply say 3.8 does nothing, it's all 3.2, but 3.8 does the job by talking about the combined effect. The fifth submission I was making was in relation to the consequences, and those have been fully developed already. The first consequence, which simply shows this cannot be right, respectfully, it is that the court is then required to investigate the actual effects of the whiplash injury And my own submission notes had included words which have already been employed by the court, such as counterintuitive. I mean, it simply doesn't fit with a scheme which is set up to create a cheap, accessible and workable system, to then say, actually, you now need to engage in reporting upon the details of the whiplash injury. What should happen is this person sustained a soft tissue or multiple soft tissue injuries to their neck, back and shoulder, and they last for 6 months. Thank you very much. Boom, you get an award. Because the rest of it doesn't matter. It doesn't matter, but now it matters deeply on the defendant's case. And the second submission that I make, I think, has also already been drawn out by the court, which is that the defendant is right, then the claimant's award of damages for non-whiplash injury is profoundly affected by whether that injury was sustained at the same time as a qualifying whiplash injury. Now, we say that's counterintuitive and inconsistent with the presumption against inconsistency, and we reference Benyon at 26.8, and just give you the page, it's 1048. My Lords and my Lady, unless I can assist further, those are the intervenor submissions.
Thank you very much, Mr. Weir. Yes, Ms. Itchy.
I'm moving nearer to my learned friend Mr. Williams, but only physically, not at all in terms of our arguments.
We have to be able
do you need
to
me
pick
back?
you up for the sake of the live stream and the recording, so it would be better if you're beside the...
I was trying to save time, but I won't. My Lords, my Lady, the premise of the issue that is before the court is that on the facts of the test cases, there is some concurrently caused PSLA. By that, we mean that there is some PSLA singly suffered, a single upset, to use my learned friend Mr. Weir's phrase, with 2 causes. At common law, loss suffered once is compensated once, even if it has 2 causes. The first issue for this court is whether the Act has changed that so that now a claimant can receive both tariff damages and common law damages for that single upset. It is compensation, the tariff award, and it is damages. As my Lord Burrows said, that is clear from the wording of the Act itself. It is not a statutory award. We are not in Vernon and Bosley territory. It is damages. So the question is, does the Act provide that unusually that single loss can be compensated twice by the tariff and by common law damages? And learned friends have 2 radically different justifications for saying that that approach is possible under the Act. Learned friends Mr. Williams reads section 3.8 much as we do. He says it's compendious and it is simply stating that a court can provide an overall award where there is a qualifying whiplash injury and a non-qualifying whiplash injury. It is doing no more than that. We agree. Section 3.8 does not provide a hook for the court to permit double recovery. does that hook on Mr. Williams's case come from silence, from the fact that the Act is only setting the damages for the whiplash injury and not for the non-whiplash injury? We say no, because that would be a positive reading into the Act that double recovery is possible. And more than is possible, double recovery is required in every case. My learned friend Mr. Weir, clearly as troubled as I am, that cannot be read into silence, tries to find a hook. And he finds the hook in section 3.8, reading it diametrically opposite to the way that my learned friend Mr. Williams reads it, albeit supposedly in support of the same outcome. He said that he slightly departed from Mr. Williams's reading. He doesn't. He reads it entirely differently. My learned friend Mr. Weir reads that as positively stating that whilst the tariff is damages for the whiplash injury, the court should again, at the section 3.8 stage, compensate the whiplash injury in damages at common law. And he says that's because of the word combined effect. With respect, that simply does not work. Combined effect, my learned friend Mr. Williams indicated, and we agree on this, is simply indicating that the court can provide an award which compensates for both injuries that the court is being asked to consider. It cannot sensibly mean that under the tariff, Parliament is only awarding damages by reference to duration, but never mind, because once one gets to section 3.8, one then looks at degree or other effects and gives a common law damages award as well. That, with respect, is an absurd reading of section 3.8, and it's telling that Mr. Williams has no part in that submission, albeit it was advanced supposedly in support of his cross-appeal. And in fact, the submission shows the flaw in the cross-appeal, because there is no linguistic hook that the court can attach a double award of damages. And that's not surprising, because if we apply the Lachaud test, look at the Lachaud presumptions, Parliament is not affecting the principle of double recovery being impermissible. And I won't repeat, but commend to the court the submissions I made in opening, that we are in the territory of there being double recovery here. So that, we say, disposes of the cross-appeal. There is no way that this Act can sensibly be read to permit concurrently caused loss to be compensated twice. That, it's notable, was the reading of the entirety of the Court of Appeal below. Where they differed was on the second question that we come to, which is, if that is correct and concurrently caused PSLA cannot be compensated twice, what do you do about it? And there are two options. My option, which the Master of the Rolls adopted, and the option adopted by the majority, which Mr. Williams doesn't urge on the court other than his fallback response to my appeal. We have not, I should say, snuck in, to use my learned friend Mr. Weir's phrase, an assessment of non-whiplash damages somehow as a percentage of the tariff basis. He's done some mathematical calculation on the facts of one offer made in one case at an early stage. I can simply say that that is not the basis upon which we say the non-whiplash PSLA, that PSLA solely caused by the non-whiplash injury, is to be assessed. We're not saying it should be a percentage of the tariff. What we do say is that it should be valued properly on the basis of the medical evidence that's available and findings by the judge as to what PSLA is solely caused by that non-whiplash injury. And the fact that we say that so clearly is in fact the reason for my learned friend Mr. Williams's objection to my approach, that it's impractical. So can I turn briefly to that? Because as my Lady Rose said, the practicalities are a factor that the court will take into consideration because this Act is part of an overall scheme. And I want to leave the court with the assurance that our approach is not impractical. The first thing is it said a litigant in person is referred to the JC guidelines, and that's not useful on my approach. Well, with respect, it's no less useful on my approach than it is on the other approaches. First, the guidelines are just that. They set out ranges. Secondly, a litigant in person would need to have regard to Sadler as between the various non-whiplash injuries, because there may be more than one non-whiplash injury suffered.
Do the guidelines not refer to that in any way, to a totality principle, that you can't just add up? If you've suffered multiple injuries, you can't just add them up?
My lady, they do.
Well,
so the guidelines refer to that principle. What I mean is one can't look at the guidelines and simply come up with a number on the majority approach any more than one can come up with a number on mine, because they are ranges, they refer to Sadler, and indeed on the majority approach, Sadler also between the non-whiplash and the whiplash. So if this is a problem, it's more of a problem, if I can put it that way, on the majority approach than on my approach. The second point about impracticality was the medical evidence. It said that on my approach, the medical evidence becomes unduly complicated. I hope I made the submission clearly in response to my Lord Burrows earlier, but may I reiterate that we say this doesn't require a sea change in the medical evidence that's going to be attained. It may need some tighter focus, but can I stress that the same questions as are being addressed on the majority approach are being addressed on the Master of the Rolls' approach. The medical evidence is addressing the fact. All the medical evidence needs to do is identify what PSLA is concurrently caused. It is simply wrong that on my option it needs to look at counterfactuals to say, well, what might or might not be caused. That doesn't come into it. It's a simple question on both option 1 and option 2, option 1 and the majority approach. What is, as a matter of fact, the concurrently caused PSLA? The difference between us is then on the legal answer of what one does with that medical information. We say if it's concurrent on the facts, then the Act gives us the answer. Legally, it's only the tariff that applies to that concurrently caused PSLA. That doesn't require complicated counterfactuals because logically, once the medic has identified what is concurrently caused PSLA, that which is left over for the non-whiplash injury is that which is solely caused. And that then falls to be valued by the court at common law damages. That is not me improperly prioritising one injury over another or seeking to aggregate all the PSLA in some way to say it's only caused by the whiplash injury. It's just reading the Act. The Act says that PSLA caused by the whiplash injuries is compensated by the tariff, and that includes PSLA whether solely caused by the whiplash injury or caused by another cause. So our interpretation, we say, is right as a matter of principle. It's the only interpretation which follows the clear wording of the Act, and I hope I've given the court the assurance that it is also a perfectly practical one. My Lord President, I appreciate I have gone, I believe, 10 seconds over, but there is a point that my learned friend and I would jointly wish to raise with the court, and that is the issue of costs. I put it that way because there is no presumption as to what the outcome is going to be.
We normally deal with costs after we've given our judgment.
My Lord President, I appreciate that, but the guidance was that if we're going to ask, if anyone's going to ask for anything other than the norm, it may be helpful at least to indicate that at this stage.
Yes, certainly.
It's a very short point, which is whatever the outcome, the parties are agreed because of background funding arrangements that the appropriate order would be no order as to costs.
Well, it's helpful to know that. Thank you very much. Well, can I say with more than usual sincerity that we are very grateful to all counsel. We've had a very clear submission of each of the respective points of view, and we're grateful for that. We're also grateful for the brevity of the written submissions. We set some years ago a maximum of 50 pages, which seems to have evolved into a target. And this case is notable for the fact that the submissions were appreciably shorter, as indeed there was no need for them to be any longer. So we appreciate that. Very grateful to you all. Appreciate that this is a case of some practical significance, so we will try not to keep you waiting too long for our judgment.